a little bit in my seat. Just know that I'm rebalancing here as I'm trying to get back in regular shape after triggering this gnarly sciatica on my right hip a few days ago. Um, so please write down your questions, and I'll do my best to tackle them as we get closer to the end. So with that said, we're focusing today's conversation um, on Proposition 13. I'm sure you've heard of that in California. Prop 13 or Prop 58 is the reference for the amazing benefit that we have as real estate owners in California with respect to property taxes. And you'll see that sort of highlighted when we talk more about transferring real property interests. So we're talking about transfers to loved ones or to adult kids. And again, as most of you already know, a lot of Bay Area homeowners have very low assessed values for property tax purposes. So oftentimes, if you're um, going into a new neighborhood, and let's say that there's a purchase of a house for $2 million, it's not unheard of that some of the neighbors there, right next to that property that's worth $2 million, it's going to be paying upwards of $20,000 per year in property taxes. It's not unheard of for their neighbor to be paying only $1,000 of property taxes, right? Because either they acquired it a while back and it's grandfathered in, or they acquired it from a parent or a grandparent. So the thing that, if you've worked with the county assessor's offices, you've seen very, very closely that with any sort of conveyance document that's recorded, they're always focused on whether there's a change of ownership. So that, as you can imagine, they can reassess the property tax to the fair market value and start collecting more taxes. And the caution is that overall, if the cat is let out of the bag, it's kind of over, right? If you transfer all or part of your interest, you may immediately cause a reassessment. These are things that can be avoided. Um, I'll give you a quick example. And these are things that we see quite often. Is that we meet with a couple, an older client, and they'll say, we have two pieces of real estate, and oh yeah, by the way, we've actually added our kids' names to title already, right? They're trying to do probate avoidance. They're trying to do other things by trying to be smart. They start adding kids' names onto title. Um, and sometimes they add the in-laws' names because everyone's a part of a family, right? They add the daughter's name and then the son-in-law's name without really understanding that transfer to the son-in-law could potentially be triggering a reassessment and not directly going through the daughter. So we see this quite often where people are doing it yourself and recording deeds and not really understanding that they could be losing out on the property tax benefits. As we get going here, just to kind of capture your attention and show you the powerful nature of these techniques, for one of my clients that we worked on these techniques with, um, a family that has two adult sons. The family lifetime transferred significant parts of two pieces of commercial property to their adult sons. When we did the numbers for the amount of property tax savings that the sons were going to have um, during their lifetime, it was over $1 million. right? Just in the property tax savings um, during the adult child's lifetime, um, it was over $1 million. So that's not just in, income tax or estate tax. We're just talking about that often overlooked local county property tax, right? Bobby, I'm not sure what the scribbles are. They're showing up, and I don't know if maybe I'm doing it, but I'm not sure.
Hang on. Let me see. I think we got somebody in here. 1 second.
No worries. I'll keep going, Bobby. Um, so when I was referring to that, $2 million house, that it's about $20,000 per year, right? Give or take. That was just this rough estimate based on these figures. It's 1%, as you all know, and then plus any local or special assessments that show up. Sometimes we see those special assessments from the high school swimming pool or what have you. So that's not unheard of to see that be dramatically higher than 1% per year. Um,
Hey, Amir,
yeah,
can you go to uh, annotate? I'm sorry, somebody, I don't know why people do this, but can you,
the real estate for the money being transacted. Um, Prop 13 is very sweet, as we all know, but it's not it's not etched in stone, right? There's a 2% increase that the county can do every year. Um, in all seriousness, I would encourage everyone to double check their yearly notices and assessments. For just speaking personally, for a property, this is maybe at least 10, 12 years ago. It was like a little studio condo in San Francisco, and the assessor's office was saying that this little closet was worth, such and such dollars. If you see that the county is increasing those values, and you sense that it's not reasonable, there's a way to contest that, right? There's a way to come up with your own appraisal and go in front of a appeals board and contest those values. So keep those things in mind. And the county does make mistakes, you guys. It's not uh, all computerized. It's definitely semi-automatic, and they've been known to make mistakes. Yeah, Prop 13 allows, and I just mentioned this, right, for increases for new construction and decreases based on decline in property values. So this, I'm not clairvoyant, and every time I've tried to be clairvoyant, I've had egg on my face. So I'm not saying that the values are changing, but this may be a time, right, especially for, let's say, San Francisco County, maybe next year some folks may want to challenge the values that are showing up on their property tax bills, because they legally can. If the values are lower, you can substantiate it and get an appeals. So there's a three-part test to change of ownership. It's basically a change in the present interest, the current beneficial use, and substantially equivalent to fee value. So what is this stuff really trying to get at, right? The county is trying to figure out whether there was a current transfer, but one that there was still a little connection to the grantor, where the grantor was retaining a right of occupancy, where the grantor was retaining a life estate, but still doing a present gift, right, of the remainder interest. That's what the county is trying to figure out, whether there's been a real change of ownership. And of course, they look through those deeds. If there are trusts involved, then they will for sure ask for a copy of the trust. They're legally allowed to do that, to figure out who the ultimate beneficial owners are going to be. So just to be clear, these these terms are
Okay.
interrelated. The trust,
Oh, 15th, yeah, September 15th. Okay, yeah, I didn't
uh,
know.
the trust and the beneficial use versus the legal owner use. That those are interrelated. As you all know, a trustee can be a legal owner, but the property is not theirs. The beneficial use could actually belong to the beneficiaries, right? That the equitable ownership belongs to them. So the county assessor wants to know information about those people, not necessarily the person who's on title that says Mr. Smith as trustee of the trust, because that's not indicative of who the actual owners are and whether there was a change of ownership. Um, this kind of speaks for itself. Adding, deleting an owner can definitely cause those inadvertent transfers and change of ownerships. Let's talk about some exclusions. Let's talk about some safe harbors, right? So oftentimes we see LLCs in the realm of rental properties, right? And if you've ever wondered, oh, how was it possible that, let's say it's you and a sibling, right? You own a rental and you and the sibling transferred the ownership to an LLC. If you're wondering, wait, why did that cause a change of ownership, right? Well, because there's an exclusion for it. There's an exclusion that says whenever there's a proportional interest being transferred from the grantor to the grantee, right? The owners are the same. Then there is no reassessment. There's an exclusion for that. So let me say it again. Two brothers or two siblings own rental property 50-50, and they transfer their shares inside of an LLC, where within the LLC, there's still 50-50 owners, right? No change of ownership. And guess what? The county assessor is, of course, going to look at the operating agreement. They're, of course, if it's a corporation, not that you'd ever want to put rental property in a corporation because that's not ideal at times, but they're, of course, want to look at the bylaws. If it's a partnership or a limited partnership, of course they're going to want to look at the limited partnership agreement because that's ultimately how they'll figure out who the beneficial owners are, right? So that's one exclusion. If for whatever reason the LLC owners ended up being 90-10 in my example, right? Why? Just because the two siblings decided that way. They're carving up the turkey according to the way they want to do business, and they say, even though on title it says 50-50, right? Which is very common with family members. When we're putting in the LLC, in real ownership, it's actually 90-10, right? No harm, no foul. Now, when you send that operating agreement to the assessor's office, they're going to be on that example and wanting to reassess part of that transfer. So that's the first exclusion, is proportional interest transfers. Please keep this one in mind for LLCs and entities, especially when we start talking about parent-child transfers for rental properties, because there's a special way of doing that and not causing reassessment. So please keep this proportional interest exclusion in mind. The county basically says, actually, I should be more precise. It's not the county. In California, it's the State Board of Equalization who is in charge of these reassessments, and they give direction to each county assessor's office, and they give these directives based on what they call letters to assessors. These I don't want to say proclamations, but these directives are on the State Board of Equalization's website. If you go to the real property tax tab, you can find all these letters to assessors and see how the State Board of Equalization governs the local counties when it comes to these types of issues. The other exclusion, which doesn't really apply that often, is when basically when there's less than 5% of the property being transferred and the value is very tiny, basically the county gives you a pass. No harm, no foul. Transfers between spouses. And now also for registered domestic partners. So let's talk about specific examples. What are we talking about? We're talking about couple owns a property together, one spouse passes away, the survivor owns 100%. The reason why there's no change of ownership is that there's another exclusion that's applicable solely for spouses. And in fact, I was emailing with a client this morning about this, even though when we're off, our office is helping a surviving spouse with the trust administration, filling out forms, recording affidavits, giving the county notice, etc. The counties almost have this factory line of notices that go out, even when they already have the information they need, in order to trip people up to get these reassessments. So for this particular surviving spouse, lo and behold, the county sent another form and said, you need to respond to us within 14 days, otherwise we're going to reassess your property. Give us the information about what your relationship was with the decedent. Of course, it's not fun, right? Because she just lost her husband, but to go through it again, you have to tell the county that you are the surviving spouse in order to make them stop, basically. All right, here's the biggie, you guys. Gets a lot of play in California. If you're tracking the news recently, I'm sure you've seen that there are, as there have been in the past, propositions to reduce the benefits of Prop 13 when it relates to commercial properties, as it's for parent-child exclusions, right? So let's talk about what the current law is right now, and then I'll scratch at what the new proposition is trying to do to reduce the benefits of Prop 13. Okay, so here's yet another exclusion. And the exclusion for parent-child works like this. A principal residence of unlimited value. Well, let me say that differently so we're all on the same page. Even if the house is worth millions and millions of dollars, the adult child, when they inherit that property and they fill out the proper forms, they get to pay what mom and dad was paying for the property tax. Doesn't matter if it's the $100,000 vacant land or a much more appreciated real estate. In addition to the principal residence, mom, dad, each gets a $1 million coupon. Mom has one, dad has one, and this coupon is used for rental properties. So besides the primary residence, right, you get these two extra coupons, mom and dad each get one, 1 million each, assessed value. So mom and dad can use the parent-child exclusion for rental property so long as the assessed value is $1 million or lower. If you're wondering, well, can it be 3 properties? Absolutely. If it's 300K, and then 600K rental properties, that can still work where the adult child or adult children keep paying the same property tax that mom or dad was paying on all of those 3 rentals, in addition to keep paying the same property tax on mom and dad's primary residence. That's the current lay of the land when it applies to parent-child exclusions to avoid change of ownership. That's basically what the current law is. Now, if you've got little questions brewing here, right? Can we have 2 primary residences, right? Can you use both mom and dad's coupon, right? If you have those types of questions, absolutely, absolutely. And we'll scratch at those things a little bit further. But I wanted to mention this. Big red stop sign. We're not talking about transfers of entity interests. This parent-child reassessment exclusion applies to the transfer of real property interests. Okay, I'll come back to that. Well, I think I just said it right here. I let the cat out of the bag. I do this quite often in these presentations. So let's go through this hypothetical where we've got a really sad child, right? So LLC owns rental property. Father is 100% member, manager, and he does a gift of his membership interest, 100% gift of a membership interest to the daughter during life. And how do they do that? Maybe they do it by changing the bylaws or by doing a gift letter. What does that mean? 100% reassessment. Why? Because it's a transfer of the entity interest, not of the real property interest. Could this have been done differently and avoided? Absolutely. We kind of went through this in a different permutation earlier. So I was talking about the two siblings owning an LLC together, right? Let's change that hypothetical and start talking about a father and a daughter being two members inside an LLC. So in this particular example, you've got, prior to moving the interest of the property to the LLC, right? The father transfers 10% of the real property interest by gifting it, by signing a gift deed, right? I hereby gift 10% to daughter. And then together with father's 90% and daughter's 10%, together they transferred their respective interests inside the LLC. And within the LLC, operating agreement, shareholder member schedules, it shows that the father's 90% member owner, the daughter is 10% member owner, and voila, the exclusion does apply, right? So if you're wondering in this one where you have a sad child, right? Whether there's a way to avoid it, absolutely. You avoid it by gifting real property interests and then both parties transferring their respective interest inside the LLC and maintaining the same proportionate interest. So remember when I was talking about this one earlier? And I said, please tuck that away in your back pocket when we're going to talk about LLCs, right? So that now you're seeing that loop being closed, right? So as long as family members are structuring those steps and the timing of those steps accordingly and moving rental property inside an LLC, there's never going to be a reassessment. But you have to do the gifting of the real property interest first and then fund the LLC. If you miss those steps, then it's very problematic. And I graduated from Hastings 20 years ago. In my career, I've seen at least half a dozen really, really large dormant escape property tax issues, right? Where this step that I'm talking about right now, when mom and dad were gifting to the adult children, it wasn't done correctly. And for whatever reason, the county assessor at that point didn't catch it. And then lo and behold, years later, the adult kids are trying to sell the rental property that they inherited through that transaction with the LLC or the partnership, right? And guess what the county says? We forgot to increase your property taxes. This is an escape property tax problem. And the county can go back 8 years. That's their statute of limitations for being able to go back and claw back those property taxes that they never collected. In some of these projects that I'm referencing, the amounts were as large as 250K, 650K, because the real property interests, right, the commercial properties, were big ticket items. When it readjusted from the assessed value that mom and dad had to that change of ownership fair market value later on, inadvertently, right, because they didn't do these steps in the right time, the delta is huge. And then when you multiply that by 8 years, then you've got a big ouch, right? You've got a lot of unhappy clients there. Luckily, those are not my clients. I'm usually being hired to do these cleanup projects, y'all. All right, so let's talk about 2 more slides, and then I think we can take a little break and jump into questions and get a little bit more granular. So I have actually dealt with several projects where it was a transfer from grandparent to grandchild, and the middle generation was already deceased. That's the only way it'll work. And you betcha the county assessor wants the death certificates for the deceased middle generation when they're processing this paperwork. So again, what are we talking about? We're talking about the transfer that would have been there, right, from parent to child. That middle generation is deceased, but grandpa's trust says, we want the San Francisco home to go to granddaughter, right? That's the example. Granddaughter can keep paying the same property tax that grandma and grandpa were. And again, I've done some of these projects where, like, let's say the granddaughter was paying a maximum of $1,500 per year for property taxes, where the neighbors were paying $25,000 plus per year. That's the strength of that Prop 13, Prop 58. I want to scratch at the next chapter without really going too much into it. So we're talking about entities holding rental property, and now we're talking about changes within the ownership structure at that point in time, right? So the title is actually inside ABC LLC, and the changes to the ownership structure are not being done in sort of a transparent way, right? Because the ownership still remains in the name of ABC LLC, but the membership ledger on the back end is being changed for whatever reason based on activities within the LLC. In that circumstance, if you're wondering, wait, do you have to give notice to the assessor's office for those changes? No. Guess where that required notice needs to go, which is often overlooked. State Board of Equalization, right? So when there are transfers of entity interests, the reporting agency is now the State Board of Equalization. And what's the form? The form is 100B. BOE form 100B. It's about, I think it's like 5 or 6 pages. And it's very detailed. They will get at historical information as to how ownership changed over time, even from mom and dad to mom and dad's trust, right? And then mom and dad's trust, maybe to adult kids. All of those steps, the BOE is very interested in, because now they're the taxing agency tasked with figuring out whether there's a change of ownership. Now, this is, I said I wouldn't get too granular, but just my last point here. When the needle inside the LLC goes over 50% change of control or change of interest, right? 50%, the whole thing is reassessed. Like there's no like halvesies with the State Board of Equalization. There, as you've seen with real property transfers, right, that are not inside LLCs, there can be halvesies where the assessor comes back and says, yeah, we're reassessing a third of this interest because of X, Y, and Z. Not with the BOE. When the needle goes over change 50% for change of control or change of interest, that's where the whole thing is reassessed. You guys, this is often overlooked. Within my field, the estate planning field, and also with real estate attorneys, this form 100B is often not sent in when there are changes in the ownership structure. And there are latent escape property tax issues within a lot of LLCs that are discovered later, right? when is it discovered? At the time when you don't want to hear about it, when you're selling it. That's when they're gonna get grab the bag and say, not too fast. Let's figure out what the ownership structure is right now. But that's not what the BOE sees on its records at the inception point. They'll say, oh, that there must have been a reassessment here. There's an escape property tax issue. You guys, as you're sensing, I'm a big tax nerd. I'm not sure how I became this way, but such is life. I definitely get really excited about estate gift tax and property tax issues. And that's sort of my wheelhouse. I know about income taxes and can talk about it during cocktail receptions, but my strength is really in the estate gift tax and also property tax issues. I want to take a little break. I think I see questions here.
Yes, lots of questions. So Amir, if you see questions directed at you in the chat, take a stab at those. And then I have some questions as well. So we'll let your questions, let's take those first.
Sounds good. So it looks like it's from Yoram, and the is relating to the $1 million coupon that I was talking about for parent child transfers for rental property, for investment properties. And the question is the 1 million extra relating to the same county? No, as long as those properties are within California, you would still be able to get that benefit. They don't necessarily have to be within the same county. I think you are pulling from another proposition, and we'll just quickly talk about it and then move back to your second question. There's another set of propositions that allow folks that are over a certain age to take their property tax from the property that they're selling and take it to a new target property and keep paying the same property tax that they were selling before. That usually requires it to be in the same county. However, there are intra-county transfers as well when it relates to that type of transfer. I think it's for folks over 55, but please don't quote me on that. And then your second question is transfers to the LLC for this 90-10% example. What happens if later the LLC shares are transferred to the child? Great question. And I think I went through the later repercussions of that, a little bit later. I was saying if later the father transfers 90% of the membership interest to the daughter, there's no reassessment exclusion for that. That's a transfer of an LLC interest. So if they want to do it right, I know it's going to sound like a pain in the rear end, right? Take it back out of the LLC. Well, how do you do that? You guys already know. You take it out of the LLC using the proportionate interest rule, right? So as long as you back out of the LLC in the same percentages, and then the father gifts to the daughter to the right percentages that they want, maybe 100% now, right? You can do that. And there's a reassessment exclusion because it's a transfer of the property interest. Then the daughter transfers her new 100% interest in the real property interest to the LLC. But be careful, the LLC has to be owned by her 100%, not the same LLC, because the dad was part owner, right? Okay, I hope that's helpful, Yaron. Bobby, if you want to get your question in too, it looks like there's more
Sure,
questions
sure.
pouring in. I don't know.
I
Yeah,
have a whole bunch from Krista. What if I transfer a property from myself to an LLC that I'm the only owner of? So like a single member LLC. What happens in that case?
you're fine because it's a proportionate interest transfer, 100% from you, 100% to you as member of that LLC. So there's no reassessment.
Okay. Okay. And there's a follow-up. Is there any difference in this exemption if the property is a commercial property versus a residential property?
Not currently.
Okay.
I overlooked this. I promised I would talk about it. There's current propositions in place in California that yet again attempt to reduce this benefit that I was talking about. Remember the 1 million coupon that I was talking about that's available for rental properties? Currently that's available for warehouses, commercial property, etc. This new proposition is trying to limit that. So it's not applicable to large apartment complexes, etc.
Got it. Got it. I have several more. One is, what if deceased was an owner occupant at a rental property such as a triplex? Does the primary exclusion only apply to the unit or does it apply to the property?
If it's one parcel and the whole parcel was inside the LLC, then I think there's an issue there, even though the person was residing in there. I think you'd want to talk to a good accountant on that one.
Okay. Okay. And then Kim is asking, can we use land trust transfer? It should not trigger a reassessment.
Great question. Let's talk about trust now with the proportionate interest rule again, right? So when you're transferring to a trust that's revocable, usually you're 100% owner or beneficiary of the trust. So again, there's no reassessment for those. So as long as that land trust, you're still the owner or the beneficiary, it should be no problem. Oh, and I see, Bobby, I see other questions. I wasn't scrolling down. I see other questions on my thing too here.
Yep.
So we've got, how would the county know if I changed the beneficiary of a grantor trust? House is titled in trust, question mark. If the beneficiary of grantor trust on title is Wyoming LLC, how would the county know if the ownership within the LLC has moved? The county will not know. Within California, whenever if real property is inside an LLC or an entity, and there's changes within the entity structure, California law is that there's a reporting requirement with the State Board of Equalization, and that's through Form 100B. And you could just Google that, Google State Board of Equalization, and find the real property tax tab. There's frequently asked questions. It's actually a really robust site. I know some of these government agencies get kicked around, but the State Board of Equalization has a lot of great information. So that's how it's self-reporting. And if you don't self-report it, it may catch up to you later when you're selling.
Okay. Amir, I've got one
Okay.
that's probably a very common question. We want to refi our home. It's a $900,000 mortgage. We bought it 3 years ago, appraised at $1 million. Today it's appraised at 1.3. Could this increase appraisal trigger a property tax increase upon I think this is to do with refi.
Yeah, it will not trigger.
Okay.
It will not trigger reassessment.
Okay.
Yeah.
Okay.
And typically, I'm sure you all have seen in California, there's this assessor form that goes hand in hand with any deed that we always record, called preliminary change of ownership report, PCOR, right? There's all those boxes that's how they figure out whether there's an exclusion and what the value is for consideration purposes. I got a question here. What if I don't have children right now? Could the same apply to my nieces and nephews whom I will be gifting my properties to when I pass away? Some of them are not U.S. citizens. Does that matter? Let's talk about the beneficiaries that are not U.S. citizens first. Really doesn't make a big difference for folks that are beneficiaries outside the U.S. Before that transfer takes place, there's a process for getting a TIN, a tax ID number, for beneficiaries that are foreign beneficiaries. So that part of it is not that involved. But I don't have good news in terms of your question there, is that no, it doesn't apply to niece and nephews. There's no such exclusion. And let me, since we're talking about timing, let's talk about this, you guys. So let's say parents' trust said, doesn't matter what kind of property, primary residence, rental property, goes to 3 kids, right? That's what the trust says. And parents pass away, and the kids follow the instructions of the trust, right? There's a deed recorded that moves the title. Please be careful with the steps here. They're moving the title out of the trust and putting it in all 3 kids' names, right? And then 7 years later, while they've been renting it, everyone's happy. 2 of the kids say, nah, we're done with rental properties. There's actually work involved, as we all know, with rental properties, right? They don't want to be involved in it. So the 3rd child says, no, I want to keep mom and dad's property, right? But the only 3 names are the 3 kids' name on title. If the 2 transfer property to the 3rd, guess what? On the preliminary change of ownership report form, there's a 2/3 reassessment, because it's a transfer from sibling to sibling, right? How could this have been avoided? Again, I'm not clairvoyant, but sometimes if I could, I try to rewind time, right? They should have kept it in mom and dad's trust. Keep the title in mom and dad's trust until they would have figured out, what are they gonna do? One of them was gonna buy the other one out. As long as it was still in mom and dad's trust, right? And it transferred from mom and dad's trust to one child, of course, subject to an encumbrance. It has to be encumbered so that the other 2 kids get paid out according, guess what again? To a rule set by the State Board of Equalization, right? It's coming from straight from the horse's mouth. If they would have followed that step, there would have been no reassessment. So not just the exclusions, but the timing of these things is critical. You don't often need a real estate attorney or an estate attorney, but you can get this type of advice from a good accountant as well. I see we're blowing up with questions, you all. So what I was going to suggest is, you see my email address. Please don't hesitate. It's Amir@arerlaw.com. Please don't hesitate to shoot me a quick email. For all the folks that attended this conversation, I'll gladly provide responses to you guys. And I was going to say, Bobby, for all the folks that are participating, if you want to engage our services, what we'll do is we'll reduce our hourly rate, Bobby. Wow. That's what I was thinking. So we typically, Bobby, as you know, we typically charge $325 per hour. So we'll bump that down to $275 per hour.
Wow, that's huge.
Yeah, it's just something that I'd love to do for folks that we work with together.
I think my members would appreciate that.
Right on.
Like folks, like I said, Amir is one of the nicest guys. He's what I call an anti-lawyer. Okay? he's not like your typical attorneys that you may have encountered in the past. So thank you for doing that, Amir. That was a total pleasant surprise for everybody that joined. And I have two more questions, and I think we can wrap it up. We're coming up on the hour from Mukarrab. So me and my mom own a property, and I want to move it into an LLC, and I want to take my name out of the property and put my brother's name, just replace his name and put it in his brother's name. And I want to refinance the house. Will that trigger a reassessment? So I think there's two components to that question. One is swapping out his name. Let me see.
His name with his brother's name, right?
Yeah, he wants to swap out his name with his brother's name, and then he wants to do a refi.
Okay, so I think if the loan is only, it just depends on who needs to be on the loan, right? So, but trying to give a short answer to that question. If currently it's mom and yourself, right? Before you transfer to the LLC, you have to give your share to mom using the parent-child exclusion. But you're wondering, like, wait a second, but that's child to parent. It still works, child to parent still works. And then mom would then give to brother using parent-child. And then both of them would transfer to the LLC. No reassessment. But if they need, but if they need you on the refi, that's that's going to be a little dicey.
Yeah, very true. Very true. All right. Last question from Debbie. 1 million exclusion only apply to primary residents and not available to second or rental properties that are non-commercial. So basically, what does the 1 million exclusion apply to?
Currently applies to any real estate in California. Currently.
Very nice. Very nice. I think that was all the questions that I had. Folks, look, I think if you do have, if this triggered some interesting questions in your mind, and you just want to get a quick, verification on what you're thinking or what your situation is, Amir is there. He's there to help you. One of the most reasonable and the nicest guys, I think.
Right on, Bobby. You're making me blush.
No, I'm serious about that. But of course, be respectful of his time. We'll have you back again, Amir, one of these days. But folks, if you don't have any other questions, we have four speakers tomorrow. So check out the meetup site. We've got some really good speakers tomorrow. We've got a noon session and then a 6 p.m. session. But Amir, thank you for your time. I hope you get better soon.
Thank you, Bob.
And we'll see everybody online soon. Stay safe.
I have a question.
Yes.
I think I submitted to Amir. I just realized that. Would you be able to answer that?
Sure. Go ahead and repeat your question.
Oh, okay. The question is, after I changed my revocable living trust name, so currently the title of my house is under this old revocable living trust name. So I'd like to change it to the new trust name. So how would I go about doing that without being reassessed? And what is the process for that?
So it relates to the proportionate interest exclusion?
Yeah, it's still, everything is still the same. It's just the living trust name is different because, it has my name in there as the whole living trust name, and I don't like that. So then, and I don't want my name to show on my property in the record, county record.
Right. So I would suggest you do it in 2 steps. The first deed moves title from your old trust to your name as an individual.
Okay, so
You fill out the preliminary change of ownership report. One of the boxes there is that it's a transfer to or from a revocable trust. So that's the box you would check on the preliminary change of ownership report when you record the first deed to go from the old trust to you as an individual. And then the second deed is from you as an individual to the new trust. And again, you check that same box on the second PCOR saying that it's a transfer to or from a revocable trust. I suggest you do it in 2 steps instead of going from old trust to new trust, because
Oh,
they're going to scrutinize it a lot more when you go from old trust to new trust. In both ways, of course, they're going to want a copy of both trusts. Again, that's the only way they can figure out that it's proportionate interest.
so what, so do I wait for the first step to be completed first before I do the second step? Is that right? Since it is done in 2 steps.
You don't have to. If you're going to do this in person, you could walk in and record the first one first and make sure that they understand they're recording this first and the second one right after it. That's
Okay,
possible. And when
I
we're
see.
mailing it into the recorder's office, there are times where we bold that we want them to record these sequentially. So it's timing is very specific.
Okay, so if it is mailing it in, it could be mailed in as 2 forms together. Is that what you're saying?
I would do one cover letter with explicit instructions that it's supposed to be recorded in whatever order you're putting it in. And
Right.
please keep in
Okay.
mind that they're government workers. So in the upper right-hand corner where they usually put their sticker, please put a post-it, right? And put, please record first. And
I
then in the
see.
second one, please record second. Those folks are overworked. They make a lot of mistakes at times.
Okay, so what is that form called? Because I never did it myself in the past. It's all done, through, all taken care of by the realtor agent, but, during the buy and sell. But then now it's not, there's no buy and sell involved. So then if I were to put it up myself online,
Yeah. What
excuse me,
county is it in?
Santa Clara County.
Okay, so Santa Clara, you would go to just Google Santa Clara County Assessor. And
Uh-huh.
these 4 words, preliminary change, actually it's 5 words, sorry, preliminary change of ownership report, PCOR. You can even use the acronyms that it'll pull up.
Mm-hmm. Okay. All
And
right.
that's that 2-page form, ma'am.
Uh-huh. So I filled out 2 forms, is that right? 2 of the same form?
Yes, one for the first deed, one for the second deed.
Mm-hmm. Gotcha. Okay. And then in terms of the cost, how do I pay for when I mail it in instead of doing it in person?
So first you mail me a check for $500. Just got to make sure everyone's awake here, right? In all seriousness, ma'am, please send a check not to exceed. So for the recording fees, what we usually do is underneath the line, we put not to exceed, for example, $150. Because at
Mm-hmm.
times it's very difficult to calculate the exact numbers. Each
Mm-hmm.
county has a sliding scale. So that's the
Mm-hmm.
way we do it. We include a check not to exceed a specific amount, and they calculate it themselves and then they put it in the check.
Oh, okay. So I do mail them a physical check, but then just specify not to exceed whatever the amount it is. Okay. So since I'm doing 2 deeds, so would that be whatever the cost is times 2?
Correct. Is it owner
Okay.
occupied?
Yeah, yeah, it is. Yeah. Like I said, it's just changing the trust name.
I wouldn't do it more than 150. I think 150 is very generous. It's probably going to be $70 for both ways.
Oh, for both of them? Oh,
Yeah.
okay. $70 for both, I see. Okay. All right,
Yeah.
great, wonderful. So would you know on top of your head the number of the form, or just Googling on that assessor office, it will show up like what you mentioned, PCOR?
Yes, ma'am. Those 4, it's very common. PCOR, you'll be able to find it.
Okay. All right, great, wonderful. Thank you very much,
You're
Amir.
welcome, ma'am.
Great. All right. I think we're slightly over time, but thanks everybody.
Thank you, Bobby.
Yeah, thank you, and we'll see you tomorrow. All right. Have a wonderful day.
Bye, everyone.
All right. Bye-bye.